And that will move us to our final case of this afternoon. It'll be case number 240249. State of Iowa Appellee versus John Walter Spooner Appellant. And it's the court's understanding that the appellant is represented this afternoon by counsel Theresa Wilson, and argument will be made by Kyle Kopf, a student practitioner arguing. Is that accurate? All right, very good. And then the appellee will be represented by attorney Joshua Henry. Mr. Kopf, anytime that you are ready.
May it please the court? Counsel. My name is Kyle Kopf, and I'm a law student intern representing John Spooner in his appellate matters. Before I begin, you will notice that I have a stutter. I've stuttered for my entire life, and it is not because I'm nervous. Please let me know if you'd like me to repeat anything during the argument. After Mr. Spooner's conviction for first-degree arson, 2 newly obtained expert reports would change the outcome at his trial. The basis of this appeal is 2 of the 4 requirements to grant Mr. Spooner a new trial. If Mr. Spooner's attorney, in the exercise of due diligence, could have obtained the reports prior to trial, and if the 2 new expert reports would probably change the outcome at his trial.
That we can deal with the sort of procedural knot that's tied up with judicial notice of the other case file, the FECR, that involves the homicide. It's an unusual request for judicial notice, but I wonder if you can address the Gale case and the Washington case, which essentially say, without consent, we don't ordinarily take judicial notice of other files.
Of course, Your Honor. And looking at the case law, the rule that asking about, it's unclear when that rule, when it appeared in the case law, what the basis of that was. The case states, I believe, cites 3 other cases on the issue supporting the proposition that consent of the parties is required. Of those 3 cases cited by state's case, I believe only 1 contains the rule about agreement of the parties, but it cites the other 2 which don't contain that requirement. Looking at the Iowa rules of evidence, the Iowa evidence rules don't contain that type of requirement. Specifically, Iowa Rule of Evidence 5.801 sub B sub 2 gives this court discretion to take judicial notice if it can, quote, be accurately and readily determined from the sources whose accuracy cannot reasonably be questioned.
Stand your criticism of the Supreme Court's, I guess, lack of grounding for that principle. I appreciate any law student willing to criticize the Supreme Court, but here we are at the Court of Appeals, and I think I am stuck with what they have said. Do you disagree?
Given that it was a Supreme Court case, I don't, but I would also urge the court to look at 5.801 sub C sub 2, which provides this court must take judicial notice if a party requests it and the court is supplied with the necessary information. Here, the other information from Mr. Spooner's murder trial cannot reasonably be questioned. It's reliable. So given the mandatory nature of 5.801 sub C sub 2, I would urge this court to take judicial notice of the involuntary manslaughter conviction.
A related question to that. I mean, even assuming we do have discretion and it would be, potentially permissible, the district court didn't have that, and shouldn't we be limited to the information when we're ruling on whether the district court properly denied the motion for a new trial to what was before the district court? How is it that this would be a case where it makes sense to look at other outside information it didn't have?
Given the timing of the two cases, Mr. Spooner's murder trial occurred after Mr. Spooner's first-degree arson conviction. I apologize for not being knowledgeable of when the order about the new trial occurred, but again, given not only the discretion the Iowa rules of evidence, but the mandatory nature of 801 sub C sub 2, I would urge this court to take judicial notice, and importantly, in that in Mr. Spooner's murder trial, the instructions presented to the jury explain the law as requiring the jury to believe Mr. Spooner committed first-degree arson, to find him guilty of first-degree murder, because arson first is, as explained in the instructions, a forcible felony. After hearing the testimony of the two new experts, the jury did not convict him of first-degree arson, which is strong evidence that it would change the outcome at his trial. But again, I want to emphasize that this court taking judicial notice is not a requirement to find that the trial outcome would probably be different.
Before we get to the outcome, we can talk about the due diligence prong, which I think comes first in the list. As I look at this record, Ms. Watt represented your client below. She's an experienced public defender, certainly not her first Class B felony. It strikes me that if she wanted a continuance, she would have asked for one. Why isn't that the end of the analysis, that this was a gamble that just didn't pay off in your client's favor?
The continuance issue isn't the end of the analysis for three reasons, Honor. Number one is that, of course, the defendant's trial strategy changes in response to the state's experts. Given the information Mr. Spooner's attorney was knowledgeable of at the time she was presenting a reasonable trial strategy, which was a defense of voluntary intoxication. The due diligence standard only requires a reasonable effort to investigate Mr. Spooner's case, which he did pursuant to her reasonable trial strategy. Two is that the timing of state's reports were delayed because the state miscalculated its timing of charging Mr. Spooner. The state charged Mr. Spooner before it was prepared to bring him to trial within 90 days. And as a result, it disclosed its experts' report basically at the eve of trial. State disclosed its state's arson investigators' report a mere 7 days prior to trial. It was after the 10-day deadline for that type of disclosure. Given that Mr. Spooner's attorney was in a different trial that week, and based on the information he had, I believe state's arson investigator did not discover the melted cords that defendant's arson investigator discovered after trial, and state's chemistry expert did not conduct the molecular analysis that defendant's chemistry expert conducted after trial. Given the timing, given the fact that Mr. Spooner's attorney had no reason to believe that state's own experts did not discover evidence, I would urge this court to not apply the due diligence standard to hold Mr. Spooner's attorney to a higher standard than state's own experts. I believe that answers your question about a continuance, Your Honor, but additionally, Mr. Spooner, this was up against his speedy trial rights as well. Mr. Spooner had a constitutional right to a speedy trial. The state did not have a constitutional right to a continuance. This court should not use the lack of a continuance, given Mr. Spooner's demand for speedy, given the timing of state's disclosures, and given the trial strategy that was reasonable to pursue with due diligence against Mr. Spooner's attorney. And I want
kind of bargain that people make in the district court all the time. I think Ms. Watt almost says it out loud at one point in the transcript. Her goal was to force the state to trial unprepared, and that's a gamble that I think made a lot of tactical sense at the time, and it just didn't play out in your client's favor. So why should we reward that gamble by granting a new trial now?
I don't think it is rewarding the gamble. And I want to emphasize that the standard isn't could the evidence have been discovered prior to trial, period. The standard is could it have been discovered with due diligence. Given Mr. Spooner's attorney's strategy was to present the voluntary intoxication defense, and again, she had no reason after the state's late disclosures to believe that state's own investigators did not discover important evidence that was beneficial to Mr. Spooner's client. It wasn't just a gamble, it was the reasonable trial strategy. I also want to emphasize that again the timing of the disclosures, given that Mr. Spooner's attorney pursued a reasonable trial strategy, investigated that reasonable trial strategy with due diligence. State also categorically argues that new expert opinions after trial are not new. If they only look at evidence from before trial, not only is that distinguishable, but it only goes to the timing requirement, which is not an issue on appeal.
Time, Mr. Kopf. I will give you another 5 minutes on rebuttal. Mr. Henry, are you prepared to proceed? All right, whenever you're ready, counsel.
Please, Court. Counsel. I'll start with the judicial notice piece. The case law, Gale, Washington, they're crystal clear that judicial notice will not be taken on appeal absent an agreement of the parties. And I think that reason is based on what 5.201 requires. So 5.201 allows judicial notice of adjudicated facts that are not subject to any reasonable dispute. In this case, while the defendant highlights select filings in the homicide proceeding, what he's really asking for the court to notice is his position that his expert's testimony in the homicide case made a difference. That's not an adjudicated fact that can be judicially noticed. It's not something that's proper under 5.201, and that's one of the reasons why the state resists judicial notice, even though in reality it would probably be favorable for some of the considerations to be before the court. Another reason judicial notice would be inconsistent with the abuse of discretion standard of review. I think as Judge Langholz pointed out, this court cannot predicate a finding of an abuse of discretion on something that was not before the district court when it issued its ruling, much less something that had not happened when the district court issued its ruling.
About that standard of review, because there's the 4 different prongs under the analysis. The case law sort of broadly speaks that the whole thing is reviewed for abuse of discretion. Are each of the prongs also individually reviewed for an abuse of discretion?
The 4 prongs under the newly discovered evidence test, the case law I don't think really spells that out. In my mind, it's kind of a mix of substantial evidence / legal error with the overall decision being an abuse of discretion. So with the abuse of discretion overarching all of those questions, what we're looking for is whether the district court's decision to deny a new trial based on its consideration of all those required elements was unreasonable. Unreasonableness generally means in the new trial / mistrial contexts that the district court's decision is not supported by anything in the record. So my position is that we're looking at abuse of discretion based on all of the court's considerations. Now, importantly, that includes the court's credibility assessments, which this court defers to.
Same logic applies to the court's conclusion regarding Mr. Spooner's trial tactics below. Basically that he made the gamble that Urenga and other cases talk about you can wait or you can go forward.
Discretion standard applies to that question? Yeah, I think it's...
For lack of a better word. And the reason I ask that is because obviously the district court did not interrogate the trial public defender about what exactly she was thinking and why she made the decisions. So there's some maybe inference drawing at work there. She makes some statements.
You didn't really need to question her. She said it. It's clear from the record, and it's clear to me. She wanted to get this case. She wanted to catch the state unprepared. That would give her 2 shots. That would give Mr. Spooner 2 shots at fighting a murder 1 beat. She had, if she beats arson 1 in this case, no felony murder. Even if she loses, she still gets to go to a second trial and challenge murder one again. Brilliant, if you ask me. So she said that. She said, this is what I do. And I think Mr. Kopf mentioned that her trial strategy changes with the information she has. Her trial strategy didn't change until the new trial motion. Of course, when you lose, yeah, your strategy is going to change. You're going to try to bootstrap in the new complaint that the state's experts' reports weren't timely. And I'll point out on that point that the correct remedy for that is either exclusion or a continuance on the front end, not a new trial on the back end. Sort of going back to judicial notice, I would also note that the defendant only requests the court to notice 3 select items: trial information, witness list, verdict. Like in State versus Washington, that does not give the court an entire picture of what happened in the homicide case. So circling back onto the newly discovered evidence, diligence, evidence probably would have changed the result of the proceeding. District court found neither satisfied. The district court was correct. So Uranga, earlier cases all require a showing that a reasonable effort was made to procure and present the supposedly new evidence. Here, the initial minutes of testimony way back in August that were filed along with the trial information disclosed the state's theory that Mr. Spooner poured gas on the porch, lit it on fire with the large blue lighter that he had. That was there. We didn't need the state's experts' opinions in hand to start to rebut that theory. The defense's decision to take a reactive rather than proactive approach to the defense is not due diligence. So what we had here was basically that. The initial minutes gave the state's theory. The defense chose their strategy. We're gonna go speedy, intoxication, insanity. None of it panned out. And I guess you don't get a do-over just because it didn't pan out. If we kind of look at the inverse situation, let's say he waived speedy, went with the expert defense, didn't pan out, and then he comes back and says, well, I should have taken speedy trial instead, so now I want a do-over to do that. It's basically the same argument, just with a little different twist. Neither one of them make any sense to me.
Is this a different case if before trial, counsel had engaged with the experts and the experts had told her, we can't really form an opinion until we have some time to work with the state stuff?
I suppose that would depend on whether after that the defense came in and said, well, we're going to need continuances or we want exclusion. Those are the remedies, not a new trial. Neither remedy was pursued in this case. So no dice on that. And the diligence requirement applies not only to the experts' opinions, it applies to the evidence underlying those opinions, as stated in all the persuasive authorities that I've provided to the court. Mr. Spooner, I think in his reply brief said,
Stop you there. Can I ask about your persuasive authorities? Is there stuff on the other side, or is everybody pretty much in agreement on this point?
I didn't find anything else on the other side. Granted, I didn't look very hard. So
Job.
I would refer to the court's wisdom on that point if you've done that research. Mine was not extensive on that point. So as I said, the diligence requirement applies to opinions underlying the evidence as well. Mr. Spooner on reply says something along the lines of, well, these melted wires were something that the state's expert didn't see, and this criminalist testing was incomplete. These are all items that were available to the defense through discovery or investigation of the scene that were not pursued with any sort of diligence. Moving on to whether the results of the proceeding would have been any different, State versus Campiano instructs that this element is not satisfied if a jury can still convict in light of the new evidence. I think that that essentially defeats the defendant's establishment of this from the get-go, because we have the district court making a credibility assessment based on the overwhelming evidence supporting the state's theory. And I'll just cut to the chase. the defendant's experts were not credible. Mr. Lentini's opinion did not disprove the state's theory that Mr. Spooner started the fire on the porch with gasoline. It only opined from an absolutist standpoint that it couldn't have come from the same gas can. Well, guess what? There were more gas cans. There was another gas can sitting 4 feet away from where the fire started. Mr. Carpenter's opinion made no sense. It was incomplete. He charged well of the fire marshal with conducting an unprofessional, incomplete, substandard investigation. But a review of Mr. Carpenter's report and his testimony tells us that he basically just walked into the living room, said, "This is the spot." It must have been either a cigarette or an electrical cord, but by the way, neither one of those hypotheses are supported by any evidence. He was wrong about the video evidence. The burn patterns and the wind direction and speed unequivocally defeated his opinion of the fire starting with the couch, jumping out the window, traveling south and around the front of the house. Turning to the blood tests, his theory with the carbon monoxide in Mr. Greider's blood requiring an underventilated fire on the inside of the house made no sense because Mr. Greider's blood had a lower level on the lower end of anyone who would die in any type of fire. I see my time has expired. I would simply ask that the court affirm the denial of the motion for new trial. Thank you.
Thank you, counsel. Mr. Kopf, you do have 5 minutes on rebuttal if you so choose. Whenever you're ready.
I want to start by discussing the trial outcome and the issue of the lack of notice. And the issue of judicial notice. While I still urge this court to take judicial notice based on the mandatory nature of the evidence, of the rules of evidence, I also want to emphasize that even if this court chooses not to take judicial notice of the lower conviction in Mr. Spooner's murder trial, that there is still sufficient evidence contained in this court's record to support the idea that the two new expert reports would probably change the outcome at trial. Specifically, in response to state's argument about there being multiple cans of gasoline, the state emphasized that one can over and over again at trial. It was in their closing statement. They emphasized it because I think it rolled down the sidewalk from the porch while Mr. Spooner was on that porch. Because Mr. Lentini's conclusion based on the molecular analysis, which again state's chemistry expert did not conduct prior to trial, it would undermine the importance of that important piece of evidence that the state emphasized over and over again. If it wasn't important, why'd state emphasize it?
As to the criminalist, I think her testimony was the reason she didn't do the test is because you're not allowed to, right?
That is correct. I think it was that she didn't know to even conduct that test or hasn't heard of that type of test.
Testimony wasn't that it was specifically prohibited by the instruction manual for the laboratory equipment?
I have the citation here. 1 second. Ms. Yoka has never seen that type of testing. That's in the transcript for the hearing on a new trial on pages 49 to 50. For your convenience, that's docket number is D0231. But in addition, but going off of that, I do want to emphasize that on the strategy concerns this court has and that opposing counsel has, that the state is equally culpable in this regard because the state chose to charge the arson early or separately from the murder. And even in the early charging of the arson, the state charged Mr. Spooner too early. As a result, it disclosed the expert reports too late. This wasn't simply a case of Mr. Spooner's attorney having discovered this evidence after state's late disclosures and not requesting a continuance. State's own arson investigator did not discover the melted cords under the couch. In contrast to state's characterization of Mr. Carpenter walking into the living room saying it started here, state's arson investigator walked through the living room, didn't find the cords, and went outside and said it started here. Mr. Carpenter, defense's arson expert, discovered the new melted cords, and his conclusion that either those cords, a dropped cigarette, or a nearby electrical outlet started the fire is consistent with all of the evidence. For instance, Mr. Carpenter explained that the toxicology report from the deceased homeowner was not in the norm for an outdoor underventilated fire because of the way the yield curve works with carbon monoxide. In that type of fire, once the oxygen is consumed, the carbon monoxide increases dramatically. So it wouldn't make sense or states for the toxicology report to contain those carbon monoxide levels unless the fire was indoors and unventilated. The mistake about the wind direction also doesn't end the Mr. Spooner's appeal because the window where the window where the fire came outside and spread to the porch was in an alleyway. Common life experience tells us that alleyways can funnel wind in strange directions, and Mr. Carpenter testified that even a calm wind can spread the fire because it's a gaseous chemical reaction. I urge this court to not apply the due diligence standard to hold Mr. Spooner's attorney to a higher standard than state's own experts who missed evidence and hasn't heard of some of the evidence. Given that she reasonably investigated a reasonable trial strategy and the two reports would change the outcome, I urge this court to grant Mr. Spooner a new trial.
Mr. Kopf. And thank you both for your arguments and also for your briefing in this matter. We will consider this matter submitted and we will issue a ruling as soon as we are able.